Julia, I think you can sit on here and then you'll...
But I mean, it's up to you if you prefer me to
No,
do it,
that's
but
fine.
I think it's smoother if you do the transition.
Allez, vous asseoir. You can go sit on the poltrona.
There is des chaises.
Yeah, there is one more down. I think so.
Ok,
I think we do.
Hello, so we are going to restart with our second panel of the day. It's chaired by Anaïs Tobalagba. Thank you, Anaïs. And I will call for the keynote speech Julia Borgianni-Batho. Julia is a deputy CEO at the Institute for Human Rights and Business. She's an expert on labor rights, forced labor, and labor migration. And she will provide a micro-level perspective on human rights and environmental due diligence and risk identification in the context and the elaboration of the UNGPs. Julia, thank you so much for being here with us. Thank you so much to each and every one of the panelists as well, and to our chair and student ambassadors. I will give you the floor. Thank you.
Thank you, Claire. Bom dia a todos. Obrigada pelo convite. Obrigada a todos da NOVA pela organização da conferência. Unfortunately, I will not speak in Portuguese. I couldn't speak in Portuguese on this topic. It's the thing that happens when you only work in English and not in your native language, so apologies for that. It's an honor to be here today. I won't be very long because I do think it's important that we also hear from the audience and get as many questions and discussion as possible. As we gather here today, we are in a very complex context. I think it's undeniable that we're going through multiple crises. We heard already this morning about the environmental crisis, the climate crisis, geopolitical conflicts. We could consider it a crossroads moment, I think, for the world. As we discuss here today in European context and European legislation, I think it's important to say that we're not alone in the world, and we need to consider the complexity as a whole. For those of you who don't know IHRB, and I imagine many of you don't know the Institute, so we are the leading global think tank on business and human rights. We work across a range of topics from migrant workers to just transitions to shipping, logistics, commodities, responsible mining, so topics that are of relevance here today. But what I want to talk about today is the role of business in this challenging contexts. When we talk about challenges and challenging contexts, I think it's important to remind ourselves that businesses are never neutral. They're never neutral actors. Whether intended or not, businesses will impact, and their operations will impact the human rights and the environmental rights of people, of communities. But business can also help ease some of these tensions and those inequalities. And that's precisely why these uncertain times and challenging contexts require much more effective and assertive business leadership. It requires business leaders to redouble their efforts to function in an increasingly unpredictable context. And business doesn't like unpredictability. Business likes certainty and stability, but also to redouble their efforts to work in a way that respects human rights, and I will talk mainly about human rights, in those challenging operating environments. Today, in this panel, we have the opportunity to discuss what it means in practice for a company to conduct human rights due diligence, and what it means to identify and prioritize risks. Of course, it's very clear that these are difficult questions that companies need to ask themselves and decisions that they need to make. But it's also clear that in this challenging context, companies need to be acutely aware that the uncertainties demand that they continually assess the roles, their impact in societies, and that they are prepared to work with others. So companies shouldn't be working alone. Governments shouldn't be working alone. These uncertain times and these challenging times require collaboration, cooperation, and consultation. One of the questions here today is why this matters, right? And I think it's important to also remind ourselves that this is important because it's the ethical thing to do. So this is not a choice. When we talk about human rights due diligence, yes, there is now a legal obligation to do so, but there is also a moral choice. There is a moral imperative, and business needs to be aware of that. These are extraordinarily difficult times, and so this requires more. It requires more from businesses, it requires more from governments, and again, it's not a choice, it's an ethical responsibility. But as we get into these discussions today, I also want to remind us all, and someone mentioned this morning, that these concepts that we're discussing are not new concepts. And since 2011, we have the framework to guide us through this, and this is not a new framework. And these are the UN Guiding Principles on Business and Human Rights. Again, as someone said this morning, they are still very valid, and they are still the main blueprint to get this right. However, the UNGPs and John Ruggie, who was one of the founding patrons of IHRB, he always said that there is no one-size-fits-all solution. What there is a compass to guide companies in this journey, and this is human rights due diligence. So we couldn't possibly sit here today and say, what does it actually mean to do meaningful human rights due diligence? Because we don't know the context of each and every company. It's up to that company and the leadership within that company to assess what is needed, to prioritize what is needed, and to really take action. As someone mentioned this morning, there is plenty of guidance out there. We don't need to duplicate the guidance that already exists. IHRB itself has produced guidance. Many others, BSR, have produced really great guidance, tools. There are many tools available. So what I wanted to remind us all is that human rights due diligence is not enough on its own. Metrics, and we talked about benchmarks and indicators, they're not enough on their own. What is important is a mix of things. It's a mix of collaboration, consultation, stakeholder engagement, metrics, impact assessments. So it is complicated. It is also true that not many companies are getting this right, but there are some that are getting it right. And so I wanted to just talk about 3 things that we identified, because we work a lot with companies. 3 things that companies that are getting this right have in common. So the first thing is that they invested sufficient resources, and I'm talking money and people, to identify, prioritize, and act on risks. 2, they recognize that these are shared challenges, and they know they're not alone. And so they are open, and they are willing, and they are actively collaborating with others. And by others, I mean their peers, companies in other sectors, think tanks, consultancies, law firms, but most importantly, they are working with groups on the ground, whether it's civil society, whether it's affected groups, whether it's workers. So they are open to consultation and collaboration. And lastly, but equally important, all these companies have placed the outcomes of these priorities and impact assessments and due diligence processes at the very core of their business decisions. So this is not for the CSR department to decide on or act upon. This is not for the sustainability team alone, and this is usually 1 or 2 people or 1 person in a company. No, this comes from board level, this comes from executive level, and this is what the companies that are doing right are doing. Before I conclude, I also wanted to remind us that it is important that we continue to look at what's wrong and what we're not getting right, but it's also vital to look at examples of good practice. And it's not easy to find them. It's not easy to find an example where someone is getting everything right. Sometimes the same company is getting many things wrong and some tiny things right. But we shouldn't forget that those nuggets of good practice can be invaluable for other companies and other actors. And so research institutions, academics, and all of those working on this topic from a sort of research and knowledge creation perspective, I urge us all to look for those nuggets of good practice and to know that even the tiniest examples will be helpful for someone out there. Also, it's easy to point at the flaws and what is missing and what we're not doing right. But again, this is not a strategy, right? We need the advocacy, we need the campaigning, but we also need strategies. Someone said business needs to coordinate their efforts, and this is a strategy. So today, as we get into the discussions, I would really encourage us all to think practically. What are some recommendations, practical steps that we can all take and that we can go out today and think, okay, this is something I can work on. IHRB has some examples of that in specific areas, and I'm happy to share more during the lunch break or, so feel free to reach out. I also encourage you to look on our website. There are plenty of resources there. It's ihrb.org. But I'm looking forward to the discussions, and I think it's important to have as much interaction as possible. Thank you very much.
Many thanks, Julia. So today we have a very impressive panel of experts in different areas of business and human rights. And we're going to start the discussion with Francisco Granja de Almeida, who is a qualified lawyer in Portugal who specializes in human rights due diligence, sustainability and corporate responsibility. He also focuses on third sector law and works closely with the social economy and impact investment communities. Francisco also currently serves as legal counsel and human rights specialist at Galp. So today Francisco is going to give us a perspective from the inside of a company, and you will highlight the challenges companies face as well as some opportunities that human rights due diligence create for companies. So the floor is yours.
For that presentation, and good morning everyone. It's very good to be here, and congratulations to NOVA for this great event and for this very well set up conference. Anaïs and I were commenting with Paul during the break that not suddenly, it took a while, but we have a real business and human rights community in Lisbon, and we're seeing ourselves and we're meeting people that we know, ex-colleagues, and it's super nice to be here. Thank you. So I only have 7 minutes, so I have to dig deep and fast into a practical perspective from who works in the corporate side. Like, how are we actually practically doing this, taking in account what Julia just said? And I would like, and our panel is about identification and prioritization of impacts. So I would like to start with identification. And identification is very simple, is what and where. What are your impacts and where are they in your value chain? And there is one key concept that I would like to present today, and we've heard it throughout the morning, and I'm sure we'll keep listening to it, called meaningful stakeholder engagement. And without it, you will probably not be doing this right. So if you want to identify the impacts in your company concerning human rights, you really have to meaningfully engage with stakeholders. And what does this mean in practice? I would say 3 things. The first is not very obvious, but I think it's part of it, which is, first of all, great paperwork and good reports. Because honestly, if a client is asking me, do you have human rights violations? What are people going to answer? You see, so it's the part that I love the most as a lawyer. I love to make the Word document, the Excel sheet, and prepare the survey, prepare the Q&A. We love this as a Word document. And we tackle these by creating meaningful documents, because it's way more value to ask to your supplier, how do you know you're not violating human rights, than it is to ask, do you have modern slavery? Because let's be honest, probably they're going to answer no. But if you ask for, show me, how do you know that you don't have modern slavery? That's a better question to be asked. So paperwork doesn't seem very important because we go, oh, it's just a tick in the box, but it actually matters if it's well put. But definitely, oh, and of course, NGO reports in the documentation side. So good NGO reports, people in the ground, industry associations, super important. But it's definitely not enough to do meaningful stakeholder engagement. So paperwork, it's definitely not enough. You really need to actively listen. You need to actively listen to those stakeholders that are most important and most significant to you. And how do you identify these stakeholders? Well, we've talked about common sense this morning, and I really think it's important to put this term on the table, particularly as a lawyer. We know that common sense and due diligence are very intertwined as a concept. But out of the legal spectrum, if we look at and we know our companies, we know how to map them, we know our activities, and we know who our key suppliers are, common sense will lead us to risk areas. Some areas are more risky than others, right? So then you have this common sense working, and you meaningfully listen to your people. And the third point would be local approach. So desk work is important, listening is important, but the local approach is key. Very key when it comes to identifying risks. And I mean a local approach from internal stakeholders, so your business units, the people that are actually making the business, because sometimes we work at the corporate center and we are a bit far away from the reality of the business units in the company, so it's really important to listen to the people in the ground, but not only your internal stakeholders, also your external stakeholders in the ground. And I have a quick story that I would like to share with you about this, which is the nurse story. Because I was once with a client working with a company to go to do an inspection to a construction site. And obviously you go with the health and safety team, and they have those Q&As that we've prepared beforehand. How tall is the fire extinguisher? Do they have the safety kits? You know what I mean? So it's the tick in the box experience, which is important. And we were talking to the nurse about how things were going. Obviously, this nurse was working on the construction site, and the company, it's not operating in the construction site. It hired a contractor, and the contractor hired the people that are working in the construction site, that then hired their own people through empresas de trabalho temporário, so service providers, right? So this is value chain in real life. And we're talking to the nurse, and I was particularly concerned with migrant workers, because there's an area in Portugal with lots of migrant workers at the time. And I was talking to her, and I asked, so migrant workers, do they come to your nursery? And she said, obviously they do. But this nurse was not only the nurse of the construction site, she also took extra shifts in the local hospital, and she knew all the nurses from the local hospital. So she was able to tell us that she was concerned because the immigrant workers were getting healthcare in the construction site during the working hours. They would go, they were there, it was available. The company had this in place, but she realized that they were not checking in the hospital, because she knew with the checking list that the people that she was sending to the hospital were not getting in, because she had the colleagues. So this is what I mean by meaningful stakeholder approach. You really have to listen to the people in the ground, because we were able to identify a potential impact in the right to health of those marginalized and vulnerable communities, which were the migrant workers. So this is a short but example of how to do this. And this is identification. Another story that would take an hour would be prioritization. And there I just wanted to let you know that the criteria that we use to prioritize human rights impact has been available for as long as the UNGPs are out. So they've been available since ever, and they are the same criteria that we as companies are using to assess the double materiality for the CSRD reporting. So what I wanted to give you with my presentation is always see the forest for the trees and be aware that when you're using criteria such as severity, likelihood, scale, scope, remediability, all these key criteria that are used to prioritize impacts are also useful in ESG reporting. So it's very crucial to keep this in mind. And one last note, it's coming from a corporate perspective. When we're working with the companies, it's almost hard to keep in mind the rights holders approach. Because when we're working within the company, we get there, we have a coffee, we're working for the results, you know. But when we're trying to prioritize impacts, the risk there is to prioritize, it's not the biggest risk for the company, it's the biggest risk for the people. And this is as simple as fundamental. Because often we might be tempted to think, okay, this is a big risk for us. It's our operations, it's very close, but that's not the perspective we should be using. Of course, economics and financial play into this. The CSRD is very clear on double materiality. So in practice, it does play, but it's very important to keep in mind a rights holder's approach to prioritization and not a business approach to it, but it's tricky. So yeah, that concludes my 7 minutes.
Exactly 7 minutes.
Yes.
Well done, Francisco. And I'm speaking of stakeholder engagement and working with right holders, I'm really looking forward to hearing Céline's perspective as well, Céline, who works directly with affected communities. We'll then move on to Chiara Macchi. So Chiara is an assistant professor of law at the Wageningen University Law Group. She's the author of the book Business, Human Rights and the Environment, the Evolving Agenda. Her research focuses on corporate accountability for transnational impacts on human rights, the environment, and climate change. She also focuses on the business and human rights implications of the just transition. Chiara, we mentioned the CSDDD. Can you tell us a bit more about the environmental and climate change dimensions in the CSDDD?
Thank you very much, Anaïs, and thanks to the NOVA team for this kind invitation, Claire and the other collaborators. It's great to be here, and indeed, I'm going to briefly focus on the connection between human rights and environmental risk assessment, particularly under the new CSDDD, the new directive. And of course, there are many reasons, I think, many good reasons to argue that human rights and environmental risk assessment should go hand in hand and should be the basis for credible due diligence processes. And of course, the most obvious of these reasons is that very often environmental impacts have a clear human rights dimension, clear human rights implications. For instance, the massive use of toxic pesticides in agriculture, which maybe we will hear about in the next presentation, is an example of an environmental impact that has a clear human rights dimension on the right to health and so on and so forth. So it will be unconscionable for a company to consider human rights and environmental impacts in silos. However, beyond this, there are other reasons to argue that companies should always make this connection. And this should be done since the project design, in my opinion, so not waiting until the impacts are already there or materializing. Indeed, the failure to consider the links between human rights and environmental impacts can lead, indeed, to flawed project designs in the first place. For instance, this happens when the projects designed with in mind positive environmental or climate change impacts are put in place without considering the human rights impacts, the potential human rights impacts of those projects on local communities. Just to take one of the most well-known examples, the establishing of wind farms in Norway that led to the violation of the rights of indigenous peoples, the Sami, in that area, and led to a sentence by the Supreme Court, the Norwegian Supreme Court, against the Norwegian state. So the failure to integrate environmental, human rights, and climate change considerations in project design and in due diligence, in impact assessments and due diligence processes can lead to conflict, it can lead to lawsuits, it can lead to irreversible damage. So let us look briefly at whether the new directive adopts an integrated or holistic approach to these issues, or whether it adopts a silo-based approach to environmental and human rights impacts. In my opinion, the answer lies a little bit in the middle, in the sense that the annex to the directive refers both to human rights and environmental impacts. As you might know, the annex of the directive defines what is meant by these impacts. And the annex also makes an explicit connection, actually, between human rights and environmental impacts. Indeed, it refers to environmental impacts both in a strict sense, so as violations of specific provisions contained in international environmental law instruments, but it also refers to environmental impacts in a broader sense as measurable environmental degradation that impairs access to certain human rights. So it makes an explicit connection between the two. And according to this, companies are indeed required to identify and address the risk of causing, for instance, water pollution. The directive talks about harmful emissions or deforestation, which in turn negatively impact human rights. So the connection is there in the directive and requires an integrated impact assessment or risk assessment. This suggests indeed an integrated approach, and one might wonder whether this integrated approach also includes climate change or not. On climate change, it is true that the directive mentions climate change in a specific article, Article 22, separately from the general due diligence obligations contained in the directive. So Article 22 does not create an across-the-board obligation to cut emissions. It is separate from the due diligence obligations, and the annex does not even mention the Paris Agreement. So one might be tempted to think that actually climate change remains in a silo and is not to be considered in connection with other impacts. However, if we look again at the annex, companies are indeed required to identify, for instance, harmful emissions that might impair the enjoyment of human rights on the one hand, and these harmful emissions maybe could be interpreted also as greenhouse gas emissions. And secondly, they have to identify environmental degradation that substantially adversely affects ecosystem services, which in turn have impacts on human well-being. So while not explicitly mentioning climate change, a coherent interpretation of these definitions, in my view, leads us to conclude that at least those large companies that have a measurable impact on climate change, and we can now measure that impact, should consider in their risk assessment not only the environmental and human rights aspects in general, but also the climate change aspect. And indeed making sure that through their substantial contribution to climate change, they are not also contributing to environmental degradation, loss of ecosystem services, and human rights impacts as defined in the directive. And it's interesting because some of the large companies that are within the scope of the directive are actually major contributors to climate change, and this resonates a little bit with what the recent appeals judgment in the Milieu Defensive versus Shell case in the Netherlands found. The court, while finding in favor of Shell, actually underlined that some large companies have a special responsibility for climate change, and therefore they should act in a certain manner. So while it is too early to draw conclusions on the application and interpretation of the directive, because it is not implemented in the domestic law of member states yet, only yesterday I think the Dutch government issued the first draft of the implementation law. So it is a bit too early to draw conclusions, but I do believe that there is room to argue that an integrated approach to risk assessment in the human rights, environmental and climate change sphere is needed under the directive, and this approach best serves compliance with the new directive. Of course, if this interpretation holds true and it's confirmed, then the key challenge will be to provide adequate policy guidance to businesses on how to do that. So I will leave it at that for now, and thank you very much.
Thank you very much, Chiara, for highlighting the obligations or future obligations of companies, as well as the limitations of the directive. And that links very well with our next presentation, which will be given by Cannelle Lavite, who is a French-trained lawyer specialized in the development of transnational litigation in the context of business and human rights. She's the director of the Business and Human Rights Program at the NGO European Center for Constitutional and Human Rights. So ECCHR has filed a complaint before the OECD National Contact Point against Bayer for failing to properly identify and address some human rights and environmental risks in its activities in South America. Cannelle, can you tell a bit more about the complaint, but as well your perspective and the perspective of ECCHR on what the companies should have done better?
Yes, this is working. Thank you very much, Anaïs, and thank you to the organizer for having me again this year in this conference. I hope, Julia, I won't disappoint you too much, because I am focusing quite a lot on the flaws, I have to say. It's a professional deformation because, yes, we are filing a complaint against Bayer together with 4 NGOs of Bolivia, Brazil, Paraguay, and Argentina, and 2 other German organizations. So our strategy is really focused on legal accountability and corporate legal accountability, because I think this is really part of the toolbox that we have at our disposal to make sure that environmental and human rights due diligence becomes a reality and actually prevents human rights violations. But I will try to bring a bit of a constructive insight into what we believe Bayer should have been doing. So this this complaint was brought before the German National Contact Point in Germany against Bayer AG. And communities that are living in areas in Argentina, Brazil, Paraguay, and Bolivia are denouncing severe human rights and environmental impacts as a result of the predominant agro-industrial model that's based on high level of land concentration, genetically modified soybeans, as well as the intensive use of toxic pesticides, such as glyphosate. So following its merger with Monsanto in 2018, Bayer has established itself as the most important player in the production, the marketing, but also the distribution of the 2 main commodities that are really underpinning this agro-industrial model. And these are the genetically modified soybeans, but also the pesticides to which those genetically modified soybeans are resistant. So what the complainants have done, and I will go only very briefly into this, is to investigate Bayer's operations in the so-called Southern Cone, so those Latin American countries. And for each country, they mapped which communities were negatively impacted by Bayer's operations. They highlighted 3 main risks that, according to their legal analysis in light of the OECD guidelines, are significant. So very briefly, because I want to spend more time on the identification process. Socio-territorial conflicts, which basically lead communities with no choice but to selling or leaving their land or in their toxic conditions. And this has an impact, obviously, on the right to land and the right to food. Second risk is the environmental damage, which also has obviously links to human rights violations. But this environmental damage is linked to deforestation mainly, which is one of the greatest impacts of large-scale cultivations of glyphosate and genetically modified soybeans. And we have to note that the Cerrado, the Amazon, and this region on which the complaint focuses is one of the most important ecosystems in the world and has an impact, therefore, on climate change. Also, excessive pesticides use contaminates soil, water, and exacerbates already existing environmental degradation. And the third impact that was identified are the health impacts, basically through the pesticides intoxication, due mainly to improper fumigation practices. So what we've done in this complaint is that we went through the process led by Bayer to scope and identify the risks related to its operations in Latin America, and I'm just going to highlight some of the failures that we've identified and the recommendations. The first one is the lack of sectoral and geographic context. So sectoral, as you were very rightly pointing out, there needs to be a sectoral analysis for any potential adverse impact for the very specific agricultural sector in which Bayer is operating. And this is lacking entirely from Bayer's responsible business conduct policies, and this is very serious because these are the risks that the complainants have identified, but it's also more serious because these are the very risks that the OECD FAO guidelines have identified as particular risks in the agricultural sector. So one of our recommendations is that the identification of scoping of risks should include those very specific guidance that already include sector-specific risks. Also, very importantly, the various OECD guidelines mention the concept of red flag locations, which are basically defined as locations where operations are planned or agricultural products originate from, where there is already a conflict, where there's poorly land definition or disputes about land rights, where human rights violations are already occurring, where communities face food insecurity, poverty, water scarcity. All of this should be red flag locations, and that has an impact for prioritizing then the risk, but it also has a consequence on the type of measures, mitigating measures that should be taken, because it should trigger, according to the guidelines, enhanced due diligence. The country website of the 4 countries I've mentioned merely refer to Bayer's group-wide policy. They do not include a geographical, no sectoral analysis for the identification of risk. They only do this geographical refining once the risks have been identified without taking into account the specific contexts. Second point, the downstream element. So the guidelines explicitly mention that risk identification should include or should cover all the company's business relationships and should also be done downstream. This includes, among others, business relationships with business partners that receive, license, purchase, or use products or services. In the case of Bayer, we're talking about the distributors of the genetically modified soybeans and the crop owners. And there comes again the concept of red flag business partners, which are partners that are known to not respect the standards contained in the guidelines, or partners that are operating in red flag locations. And obviously, since the red flag locations are not included in the risk assessment of Bayer, the red flag products and business partners are not included either. So there, our recommendation is to include this business, all the chain of business actors, including downstream, in the risk analysis by Bayer, to potentially elaborate a supplier code of conduct, which would include the possibility of on-site visits, not by auditors hired by the company itself, but also by major business partners, and also to conduct after-sale follow-up measures such as trainings on how fumigation distances should be respected and what are the quantities as well as the protection measures that should be put in place. The third element that I wanted to mention, and it's the last one, would be the foreseeable use of or misuse of the product. There again, the guidelines mention misuse of product should lead to red flag products. And in this regard, the OECD FAO handbook states that soybean production is a red flag product because it is linked to deforestation and forest degradation. And here we're mainly recommending to Bayer to not solely focus on the general approach that as long as products are used according to labels, they're safe. This is not enough because it needs to be done according to consultation with stakeholders and to, again, sectoral analysis on what exactly are the risks that are related to this product. And I leave it at here. I hope it was not way too long. Good.
Many thanks, Cannelle, for this very practical example of potential gaps in risk identification and prioritization. But also what I found interesting is that it links to the need as well to consider different complementary standards to be able to conduct effective human rights due diligence and risk assessment. We'll now move on to Céline de Graça Pires. I don't know if I should say it in French or in Portuguese. Donc Céline is a business and human rights advisor and qualified French lawyer. She has conducted human rights impact assessment and community engagement worldwide with affected communities and indigenous and tribal peoples, and she specializes in high-risk context. She is leading a dedicated task force at the UN Global Compact France to develop the first French business guide on best practices for meaningful engagement with indigenous people and affected communities, which is going to be published by the end of this year. Céline, okay, let's say January then. So based on your field experience, Céline, can you give us a practical perspective on human rights impact assessment, but also bringing in the focus of stakeholder engagement?
Thank you. Thank you very much for the question. Thank you for having me here today. I will use 30 seconds of my 7-minute speaking role to begin by saying a big thank you and congratulations to the organizing committee of this conference. It has been 4 years, and it's amazing to see this conference growing and also bringing even more beautiful brain in the audience. So big congratulations to Professor Claire Bright and to all the team involved. So on my speaking role today, I've been asked to bring a practical insights on meaningful stakeholder engagement in human rights impact assessment and try to connect the dots. So I will structure my remarks with 2 preliminary comments and will also mention, in my opinion, from the field, the main challenge when it comes to stakeholder engagement into human rights risk assessment. It's actually called, the 3 R's we need to fix: reactiveness, reluctance and resistance, and reduce scope. So in terms of preliminary remarks, meaningful stakeholder engagement, and we need a cultural shift in this field, is at the core of the first step of due diligence, which is identifying and assessing adverse human rights impact. And by at the core, we need to bring back the UNGPs here, guiding principle 17 and 18, which says, I'm quoting, the purpose to identifying and assessing is to understand the specific impacts on specific people given a specific context of operation. So we cannot drive a human rights impact assessment if the goal is not to understand risk, adverse impact from the perspective of those affected, ensuring that all step assessment, but also our mitigation, it's grounded in the perspective of those affected and based on their lived experience, as Cannelle just mentioned. So I will not unpack meaningful stakeholder engagement today. There is a lot of guidance there. Julia mentioned it's not about duplicating standard, and we have a lot of guidance and report unpacking what is meaningful stakeholder engagement. Just for the record, OECD 2018 guidance, meaningful stakeholder engagement is an ongoing and responsive process characterized by 2-way communication and relying on the good faith of both sides. So that's for the first comment. The second preliminary comment is about who to engage, and I would like to outline a very important thing when I'm working with company. It's not about engaging the stakeholders that you want me or other practitioners in the field need to engage with. It's about, at top priority, engaging with those affected. So when we speak about meaningful stakeholder engagement, we need to understand who are the affected stakeholders and to distinguish between affected and non-affected stakeholders, because dialogue, meaningful consultation, as the UNGP put, is at the core of human rights impact assessment with those affected. And then, yes, we need to engage with other relevant stakeholders, and we have here, among the panelists, for example, NGOs that can definitely be part of the stakeholder engagement process. But the purpose is to engage with potentially and actually affected stakeholders, which mean right holder lens at the core. So that's for the preliminary comment. And with that in mind, I will go to the 3 R's we need to fix to have meaningful stakeholder engagement in human rights risk assessment process. So my 3 R's are the following: reactiveness, reluctance, and reductive scope. Reactiveness. We need companies to move beyond a defensive approach. By defensive approach, I mean in my work, I will say that 80% of the human rights impact assessment I'm conducting are coming, and my mandate is coming, after a global campaign from NGOs, after a name and shaming report, after a big incident, severe incident with sometimes dead people there. So we need to move the cultural shift. It's not a risk, an extra risk to engage with affected stakeholders. It's actually to prevent this kind of severe harm we are causing. So move from reactiveness to actually preventive approach. And there is another reason for that, is that if you send me on the ground or other excellent BHR practitioner to try to engage with an affected community, as Cannelle just presented, the trust is gone. And at very least is eroded. So you need to rebuild trust. And what about rebuilding trust with those severely impacted? You need to do the work twice. And to get it right is a really long way. So move from the reactiveness to preventive approach to avoid harm, prevent escalation of conflict. The second R we need to fix is about reluctance. Is it a current key barrier for me? The hesitation, unwillingness to engage with some affected stakeholders or to truly engage with them. Reluctance leads to a lack of engagement or superficial engagement, a token consultation, a tick-the-box approach. True engagement, and Francisco said it rightly, need to listen actively, but to have the courage to hear from the ones who criticize you the most, and not only with the community or inside the community, the ones in favor of the project. I always say to my client, if you listen to the most critics, including inside a community, apart from the leader who are supporting you, you will have the best advisors. You may be able to prevent the harm, to build a real trust. So it's about openness and inclusivity. Behind the critical voices, I see a trend of avoiding engaging with some groups like indigenous people because it's too complex. FPIC process, too complex, too risky, reputationally, at legal level, too risky. Let's not map indigenous people, we are not concerned. There is a risk in that. Of course, violate human rights standards. Them other reluctance, we don't want to engage with NGOs. Too reactive approach, they will shoot us. And we have a lovely example here, Cannelle next to Galp. That's the beginning of stakeholder engagement process. I'm killing it. But anyways, what I want to avoid here is to embrace only a stakeholder engagement approach which has a narrow focus. And I will leave that here in 1 minute. Reductive scope is the last R. It's about timing of engagement. Get it right. It means have the right time on site. You cannot do a meaningful stakeholder engagement, and I say this for other BHR practitioners because we have our own responsibility in sensibilization of our clients. we cannot engage meaningfully with indigenous people affected, with affected communities, with migrant workers in 3 days. We need time for engagement to have it the right way. If we speak about indigenous people, some indigenous communities have their own protocol. We need to respect that. It took me 2 days in one indigenous community in Guatemala to reach to the leader, because I followed the process, meaning community forum, meaning sitting several times with the leaders. We need to respect that. So it's having the right time for the right engagement, and finally not engaging with only a few vulnerable groups. You might mention migrant. I don't like predetermined lists. We need to go with an open mind, because some clients for a certification purpose told me, oh, you absolutely need Selena to engage with women, children, migrant. Good, no, that's good, vulnerable groups lens, okay. But let's go with an open mind. What about the informal waste pickers coming from ethnic minority, living in the community, very marginalized? They are vulnerable groups. In your predetermined list, they are not there. So go with an open mind on site and with the right expertise. I will leave that here. My final talk will be about security first. Sometimes we need to be humble and recognize that we need to put our best efforts in a meaningful engagement with affected stakeholders, but security first. We leave, they stay, and they need to be reassured. We need to take all the measure, companies, but also the experts that support companies, to ensure they will not suffer from the engagement. Thank you very much.
Thank you, Céline, for highlighting that, in fact, dialogue and meaningful engagement, but also trust building with right holders is at the core of human rights and environmental due diligence. But also, you know, that due diligence, and it's something that we forget a lot in our dialogues about human rights due diligence, is that at its core, it's a preventative process. So it's aimed at preventing further human rights and environmental damage in corporate activities. So I will now leave the floor to our two excellent student ambassadors, Luis Prata Castro and Sita Granja. Yes. They've prepared excellent questions for you, so I'm really looking forward to hearing from them. What I propose is that maybe we'll do one question, one answer, one question, one answer, so we can remember what the questions are before moving on to the panelists.
Hello? Yeah, okay. Hi, I'm Zita. First of all, thank you so much for your interesting insights. My first question would be for Julia regarding the diversity and sometimes conflicting nature of legal frameworks across countries. What are key challenges for companies in aligning these frameworks?
That's a very good question. So at IHRB, we work in a number of regions. So I can give examples from, say, Southeast Asia or the Gulf or many other regions where national frameworks are not necessarily aligned with European standards or international standards or standards that are the expectations of multinational or larger companies. I think a few things to consider. One is the leverage the companies have. And we speak to a number of very large companies, but even smaller companies that have an ability to influence whether it's government, whether it's other policy makers, whether it's their peers in those locations, and that cannot be underestimated. So even in challenging contexts where national legislation is not in line with international standards, companies can do a lot to influence their small sort of cohort, but also the larger sphere of influence. So company leverage is one thing. And that shouldn't be avoided, right? We hear from a lot of very well-known companies, oh, but there is very little we can do. And then we hear from some very powerful but smaller companies the progress that they made in making sure that at least their workforce, the labor suppliers they use, are complying. The second thing is also, I think, to always think that we shouldn't let perfect be the enemy of good, right? And baby steps. So when we talk about prioritizing, identifying, legal risk and reputational risk is something that companies take very seriously. But we always remind companies that that shouldn't be the driving factor behind everything they do. And I have to say, the companies that are doing the most are those that are willing to take some level of reputational risk. Because even in challenging contexts where national legislation is not aligned, you can find ways to do things differently. I can give one example, for instance, in the Gulf, where freedom of association and collective bargaining is not a recognized right in many of the GCC countries. Still, it is possible to have enterprise-level engagement with workers. It is possible to find creative solutions. So I think a number of companies also hide behind of the excuse of national legislation not being in line with international standards in order to do the bare minimum. So I would say try to do best, and best being aim high, don't aim for the lowest possible standard.
Okay, thank you so much.
Just for the panelists, I might ask you to take maybe 1 or 2 minutes so we have enough time for the audience to be able to ask questions as well. Thank you.
Okay, and then the second question would be for Francisco. How can companies balance the opportunities in HR EDD with operational challenges, and especially in supply chain tiers that go beyond the immediate control of companies, and considering also the frequent decoupling of policy and actual practice?
Thank you for the question. It's not easy because typical procurement departments of companies are very tier 1 focused. And this is how procurement has been working in companies since I've started working. So you do a screening, you get your supplier, they get one-shot picture, and then you move on and you move it. And this is the reality how procurement departments in companies have been working for a long, long time. So I guess HRDD gives us the perfect push to go with the legal leverage and say, listen, we need to change this. It's not okay to go from tier 1 anymore. We actually need to go further. And the first question is you're going to have it, to which supplier do I go further? Because we cannot do it to our 300,000 suppliers we have. And that's how it actually works in practice. We cannot do it to all at the same time with the same power. So enhanced due diligence that we've talked, it's key. Because you need to do this enhanced due diligence stronger where the risk is stronger as well. So if you know by the ways that we've just been talking in this panel that there is this area of risk in specific suppliers, yes, you can use the HRDD to really push through first tier, second tier, third tier, and actually hire those with the know-how, those who have AI tools that will check all the aduaneiro. So, customs that would check online customs all around the world to check how products are going across the states. And that's very useful because if you hire these tools, they'll do a screening and they will help you do it. I'm just giving practice. I know this is not the only way to do this, and I know that this is just the tip of the iceberg, but it's actually a tool, and HRDD has been giving us a legal legitimacy to go beyond tier 1, which is super important in our cases, I guess.
Thank you.
I would like to thank Anaïs and the organization for this invitation. My first question would go for Chiara. Regarding the overturn of the landmark 2021 case, Shell case, do you think it's that as a setback on the consolidation of climate due diligence principle? Thank you.
Yes, it works. Thank you for the question. So the appeals judgment in the Milieu Defensive versus Shell case is, of course, to some extent a disappointment. I'm sure it is a disappointment to the claimants. However, I would argue it's only partially so, because actually the Dutch court said very interesting things about the existence of obligations for corporate actors to reduce their own emissions. In particular, the reasoning of the court does confirm that under Dutch law, companies like Shell that are substantially contributing to climate change have an obligation to reduce their emissions. And this is based on the duty of care principle under Dutch law, interpreted in the light of the UNGPs, this blueprint that they continue to be, as we were saying before, and also interpreted in the light of international human rights law, Article 6 and Article 8 of the European Convention. So the first reason for optimism is that the court confirms, regardless of any explicit obligation under the public law regulations of the countries where they operate, corporations like Shell have an obligation under the duty of care to reduce their own emissions. They also find that companies like Shell do have the capacity to influence their Scope 3 emissions, so the emissions of their end users. They don't agree with how the claimants wanted to force Shell to reduce those emissions, but they do confirm that they have the possibility to do so, and probably an obligation to do so to some extent. And thirdly and finally, very importantly, the court finds, let's say in an obiter dictum, it's not a finding, but they do say that most probably investing in new oil fields by companies like Shell is at odds with their climate change obligations under Dutch law. They don't decide on the issue because the claimants did not raise the question, is investment in new oil fields compatible with the law or not? But this is an indication of an argument that might be raised in future litigation. So the court does provide very important openings for future litigation, perhaps with better legal and technical argumentation. And finally, and then I close, we cannot, as I always say, we cannot litigate climate change one lawsuit at a time. Lawsuits are very important, but they are not the silver bullet. They are one of the tools, and they are a tool to put pressure and to help governments and companies clarify the climate change obligations of private actors. So this is how it should be seen, as a tool in the toolbox. Thank you.
Thank you so much, Chiara. I will now follow on to Céline. With the CSDDD increasing emphasis on identifying and preventing and prioritizing human rights and environmental risks, what practical strategies can companies adopt to align their impact assessment processes, affected community mappings, and stakeholder engagement? Thank you.
Thank you for the question. Yeah, 2 minutes. Well, I think in my presentation I mentioned the challenges and the 3 R's we need to fight. I mean, it applies to your question in terms of community mapping, community engagement. Of course, it's not just about communities when we think about meaningful engagement with affected stakeholders. So affected communities are beyond the walls of the company, but as Julia mentioned, you have the workers, you have the trade unions inside the walls of the company. So first, to answer your question about community mapping, with one example, it's about challenging and seeing if your tools, including community mapping, align with CSDDD requirements and in light of the UNGPs. We have the criteria, we have the concept, we have the guidance since 2011. So it's a good starting point, like your community mapping, but I think there is now a work to see if we really align in terms of meaningful stakeholder engagement, for instance. So you test your community mapping with the concept of meaningful stakeholder engagement. You test your community mapping in terms of defining your impact zone. Is your impact zone only qualified with distance criteria? Or did you apply a human rights lens to the definition of your impact zone? That's the kind of question you need to ask yourself. And then on prioritization of adverse impact, I think you had a point on that. I think Francisco highlighted the criteria of the UNGPs. scale, scope, mediability, likelihood. So you have the tools and the criteria to do your salience assessment. They are there. We hope maybe the guidance from the Commission will potentially unpack the how, we see, but they are there. So it's just reading again the UNGPs would be my recommendation. No, I mean we have the criteria. It's just finally taking a management system in light with the tools and guidance we have.
Thank you so much, Céline. I would like to ask a question to Cannelle. Building on your practitioner's perspective, what would you say are the reoccurring and counter arguments presented by businesses to a meaningful interpretation of risk identification? Thank you.
Yes, thank you. I would say one that is quite recurring is the confusion still between what's business obligations to respect human rights and what's the state obligation to protect human rights. And that's a big challenge, in particular when it comes to what Céline was talking about, the meaningful engagement of stakeholders, that basically companies, first of all, there's a confusion between the meaningful stakeholders consultation as part of the risk identification and the free, prior and informed consent, which is basically the states engaging into that consultation with communities. That's the first confusion. But then within the stakeholders consultations that companies have to do, what we often get as arguments is, look, it's not our responsibility to make sure that there is no violence or that people do not receive intimidation when they speak up about the concerns on the project. This is the responsibility of the state. And there we always have to assert that, no, this is part of the obligations under meaningful stakeholders engagement to also make sure that all business partners will not engage into intimidation intimidation of stakeholders who want to speak up. And the second challenge would be the fact that pre-existing social or territorial conflicts is not an exonerating factor. It is actually a risk, and it's one risk that should trigger the red flag location. And very often, believe it or not, we do get the very serious arguments that, and it actually was an argument made by the French National Contact Point in the case related to wind parks, French wind park in Mexico, that a pre-existing conflict meant that EDF was not responsible for the violence that was happening on the land on which it was trying to build its wind parks. Yeah.
Thank you so much.
Thank you very much to you both for your excellent questions. Please, everyone, welcome. So we have a little bit less than 10 minutes for audience questions. So please, are there any questions that you'd like to ask our panelists before we close for lunch? Are there any specific questions? Yes, Beata.
Hi, I've got actually a question probably to Francesco, because you've mentioned, actually referred very specifically to double materiality and obviously human rights impact mapping and so on. Do you find the text of the CSRD and the SRS precise enough to do it correctly? No. Okay, because what we are seeing basically in Poland, it would be very interesting to hear from you how you perceive it, that actually companies that are advising big corporations on how to do double materiality just do it completely wrong, have no reference whatsoever to any history of business and human rights, and what we are getting is just a total mess. Yeah. Thank you. So is there any way out of it?
Yeah, no, it's a great question. Thank you for asking, because the answer is no. I don't think that the text of the SRS is very clear. I understand the intent of the EU legislator in giving room for the company to act procedurally as it desires, and I think that's good, like an obligation of means. But I think that, first of all, in this first year that we were all doing it, the double materiality, so everyone in the room, we're talking about ESG reporting. So we're talking about reporting under the new Corporate Sustainability Reporting Directive, so the CSRD. In order to do this, First, you need to do double materiality assessment, which is basically the combination of an impact assessment, so inside out, the impact of the company in the environment, the society, and governance issues, and inside in, a financial analysis of this impact within your economic standards. So just to put everyone, this is what we are talking about now, double materiality. I think the text is not clear. Legally, from a legal standpoint, formally legal, the CSRD is messy because it takes one accounting directive down, it changes the other. It's not easy to interpret it, to be honest, and to give clear answers. It's not like the CSDDD, which is a brand new directive, easy to read, clear. The CSRD is a bit trickier. And I've been experiencing throughout the Portuguese company sector, I'm not talking about Galp specific, real challenges with double materiality. I've issues like, and Paulo had this bullet point on his slide about ESG topics being too vague, you know? And it's been a real challenge. But going directly to your question and not taking too much time, it's key to understand that the due diligence process feeds and informs double materiality. But what I've been experiencing doing double materiality in the ground, it's that the double materiality, which is now mandatory process, is actually feeding the due diligence process. So as I said, see the forest for the trees. Companies don't have the resources to comply with all ESG regulation at the same time. This is a reality. So when you're doing the double materiality analysis in order to comply with the CSRD, keep in mind that what you're doing is risk analysis that feeds due diligence that then will comply with CSDDD. And the opposite is also true. So I hope I got that question clear. Yeah.
Thank you. So we have time for maybe one or two more questions. Are there any other questions in the audience for our panelists? Any other questions? No? Yes, okay.
Yeah, thank you. So just thinking about meaningful stakeholder engagement, right? And I would love for you to unpack this a little bit when it comes to due diligence. So I work in mining, and when we think about meaningful stakeholder engagement from a mine site, I can definitely see spending days, weeks, months, years. Can you unpack further up the supply chain as you go from the processor to the manufacturer, et cetera, all the way to a consumer-facing brand? If you think about meaningful stakeholder engagement being two-way and that there's stakeholders in terms of what that company is using to actually build their product, right? If it's a mined material, how do you bring a company, like a car company, that's thinking about its stakeholder who is next to the mine where maybe their materials come? How do they have a meaningful stakeholder engagement? Is it ever direct? What would that look like, especially when you think about how many companies would need to do that and the stakeholders that would be involved?
Many thanks.
Good luck in 2 minutes, right? Okay. So I will bring one case to illustrate my answer because I don't have time to have a more detailed answer for you. It's mainly a visibility issue. First, you mentioned cars. I can mention luxury brands. I can mention the jewelry sector. So my case is there. Jewelry sector, big brand in the market, Parisian luxury. It was the first time we sit in the same table, the mine site, NGO, local level, the suppliers, the brand, and all the intermediaries, because in the precious stone sector, you have a lot of intermediaries actually before any precious stone can reach what we call the processing. So about visibility, 1 minute. We sit everyone in the same room, Chatham House rule, confidentiality, safeguards. So finally, we have the right discussion about adverse impact and the ones affected including not only workers, subsidiary workers, but actually also affected groups. And it was a game changer to have the luxury brands actually coming on the ground. So the meeting was not, of course, that's my insight. But the next step, maybe it's actually to come with the luxury brand on site. That would be nice, right? I mean, so visibility, so you engage. That's stakeholder engagement too. And if we address the visibility issue at the very first, we can then work together in a more practical steps in terms of engagement with affected group. Yes, we enhance our visibility. So I hope it's partially answer your question in terms of first step. Visibility for me is key, especially when the sector are so far away from the ground.
Thank you, Céline. Thank you, everyone, for your questions. So thank you, Rebecca. Thank you, Beata. Please do speak to Rebecca and Beata during the lunchtime. They're really interesting people. So thank you very much to our panelists as well. Thank you for your excellent presentations and for sharing your insights with us. Please, everyone, thank you. Let's thank together the panelists.
And please join me in thanking the chair as well. And now it's time for our lunch break. So we're going to have an hour for the lunch break. The lunch will be served at the same place as the coffee break.